suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, it is time to talk legal issues, but not with David Whiting. David Whiting is taking, as we always say, a well-earned break. He'll be back with us in January. But joining you this morning, Cathy Wilson. Cathy Wilson, legal accredited specialist in wills and estates. And I think you may well have spoken to Cathy Wilson before. 1300 222 774 is the number. There are some lines free, so if you've got a question, grab your spot on the line. Cathy, good morning.
Good morning, Ali.
So you should maybe run through for people who may be a little hesitant the areas that you can address.
Yes, I'm a specialist in wills and estates, disputes with wills, disputes with elderly people, trusts and related issues, a lot of family issues that arise now with aged care, staying at home, being able to manage in your own home, powers of attorney, medical issues and the like is really the area that I specialise, although I've had a much broader practice over a longer period of time.
Because I was saying to you in the news that I've always been surprised that a will is not a will. If you understand what I mean, it's not set in concrete.
Yes, it's often said that. A lot of people say, well, you know, what's the point of having a will? It's not worth the paper it's written on. In fact, there are laws to protect it, but there are also laws that protect the individual who makes the will, who may or may not have capacity to make a will, might have been forced to sign the will and things of that nature. And there is also an obligation that's been recognised in the law for a very long time to certain dependents. So in the most obvious example, a long-term spouse, if you haven't provided for them and they don't have independent means, then the law says that you should have provided for them. They ought to be reliant upon the state and other people. So the government has changed the rules a few times, but most recently in 2016, in this case to narrow the class of claimants who can challenge a will.
How so?
For a long time, from 1998 until 2016, the law said that anybody could make a claim if you could show that the deceased person had an obligation to provide for you, and they didn't adequately do that. And so it got a bit silly because neighbours and taxi drivers and all sorts of people were making claims, and the law was doing its best to manage it, but the government makes the laws, and so there was a review, and in 2016 they narrowed the class of claimants so that now a spouse or a domestic partner, so that's same sex, any type of partnership arrangement, a child or an assumed child, stepchild, anything that looks like a child, or members of the household can make a claim, but very few other categories can. A grandchild in certain limited circumstances. So that got rid of a lot of the outliers, the people that we wouldn't automatically or instinctively think should have a claim.
How closely or specifically defined is that domestic relationship, and to what point, to what extent is it subjective?
Yes, that's a question that's coming up increasingly. It's defined by the nature of your relationship, and there are a whole lot of factors that the court takes into account, that the legislation requires the court to take into account to determine whether you have a domestic relationship, and they include whether or not you live together, so it's not essential to live together, the public aspects of your relationship, the nature of the joint commitment and contribution to the building up of your resources and things of that nature. So it's a bit like if it looks like a duck, it walks like a duck, it's a duck. You might call it something
There are many
else.
different sorts of ducks, though.
There are many sorts of ducks, and there are many sorts of domestic partners. And I've seen them all. I've seen the ones coming late in life preying upon people, and I've seen those that have been long and loyal servants helping people through serious illnesses, cancers and all sorts of things. And the law does its best to try to cope with that.
1300 222 774 is the number if you've got a question for Cathy Wilson. Anthony in St Kilda, good morning.
Good morning, Cathy and Ali. How are you?
Good morning, Anthony.
What's your question?
I have an estranged adult child from a former partnership. I've since repartnered for a number of years. I haven't seen my adult child for over 10 years. What do I need to do to ensure that she doesn't contest my estate? Now, I'm going to leave a little bit for her, but I don't want her to contest the bulk of my estates.
So she is a biological child of yours from a former relationship.
Yes.
So you can't actually prevent her from making a claim. Whether or not she succeeds depends on a whole lot of factors. So again, the courts get stuck with these questions, and the judges are really good at dealing with them, filtering out people who shouldn't be able to make a claim or who should. So I've acted in situations where a child walked away, didn't want to be part of the family, later made a claim and failed. On the other hand, I've acted in situations, I'm not saying this happens in your case, but where, for example, there's been abuse and the child has walked away and the law has said, well, you've left him or her in a dreadful circumstances, and in a sense you owe them compensation. So the only way presently in Victoria you can prevent them making a claim is to give everything away before you die.
Oh, okay. Right.
In New South Wales, it's different. I should say it's different around the country. But I would keep a record, regularly update your will, because usually if people are making claims in those circumstances, they say, well, look, we were estranged, but we band-aided up our differences and we were actually best of friends by the time the person passed away. So I'd keep your will under regular review. I would go back to your lawyer. They're the best people to keep notes for you of what's gone on, why you're estranged, the efforts you've made to try and contact your child. Don't just put a one-liner in your will to say that we've been estranged. Talk to the lawyer about how to express it in a much bigger way than that, because there's usually more to it just than you're estranged.
So you can't make there's not sort of a 10% would be deemed fair.
No.
There's no easy...
No. There's not a magic formula, and in Victoria you can't contract out of a right. It's a public policy thing, because there are some people who would leave someone out of their will, and I can give you one short example of somebody whose wife became a quadriplegic. They had 2 young children. He went off with somebody else and didn't leave anything to his young children. So the law says, well, even if he didn't want to leave anything to them, but we recognise in those circumstances that there is an obligation to provide for them. But of course, if they've got lots of money themselves, or they've been spendthrifts, if they've just wasted money and they've done drugs and hard times in jail, depending on all the reasons for that, they are factors that the court takes into account. And the judges grapple with this all the time.
And
they're very good at it.
Is there any clawback? So if someone does give away virtually everything that they have prior to death?
Yes, not in Victoria, unless you can show it happened in unconscionable circumstances, or if the person didn't have capacity when they made those.
But if they had full
decisions,
capacity?
If they had full capacity, no. In Victoria, you can't claw that back. It's a dangerous thing to do, because when you think you might pass on, you recover.
Give it away. And
you
then
give it away.
Yep, and there's nothing left.
And 99 times out of 100, the person doesn't give it back. So...
Yes, there's fair warning there. Frances in Burwood. Hi, Frances.
Oh, hi. Thanks for taking my call. I have a relative whose parent passed away, and the superannuation was put into a trust. Mm-hmm. And I'm just wondering, is there any way of finding out more details now about the trust? He's now... gone on and matured a little bit, and I've just got is there any way of finding out information about the trust?
Yes, that's got a whole lot of complexities about it. I'll try and drill it down to, is it a do you know what sort of superannuation it is, an industry or a retail fund or a private superannuation fund?
Well, the superannuation was...
with a company?
Look, I'm not sure of all of the details.
Okay, so if he knows who the superannuation fund is, he can make an inquiry of them. If there was a binding nomination, which there can be with superannuation funds, it would have been paid out in accordance with that, and you can't challenge it if the binding nomination was valid. And that's what happened, I believe. And then that trust
then that money was put into a trust.
Trust, yes. So if there's a binding nomination and it's valid, the superannuation fund is obliged to follow the binding nomination if it's valid. Sometimes they're not valid or up to date.
And actually, this is a very important point, isn't it? Because when you join a super fund, you tick a box or you put down who you want your beneficiary to be. That is not binding.
No, not necessarily. No. So there are options, and some superannuation funds, and in fact, for a long time, you couldn't have a binding nomination. The government changed the law when it did that superannuation reform package back in 2006. But now most funds allow you to have a binding nomination. But having it valid and up to date and properly completed and having been given to the fund are what's critical to those steps.
Frances, does that answer your question?
No, not
as
really.
As much as I can. There's not can I say there's not a central register or registry for superannuation funds. So if you can find out where the superannuation fund was, you can write to them. Ordinarily, you will get assistance from them if you know who the superannuation fund is with. Now, it's a bit hard. It's a bit like, you put your things somewhere. Where did you put them? You've got a bank account somewhere. There's no central repository for superannuation fund information or bank information. So that makes it a little bit hard. You can search at the probate office if there was a grant of probate of the will, and you can write to the executor. So that might be one option if you go onto the Supreme Court website, which is supremecourt.vic.gov.au, go to the wills and probate section and search and see if somebody's got a grant to administer their estate. That means that somebody's got an authority to manage the estate and receive that superannuation and pay it out. So you can go that way. And why don't you try that? If that's not getting you far enough, you might want to ring the Law Institute and ask for a referral. You'd probably need a referral to a wills and estates or superannuation specialist for that point. But I hope that gives you some pointers.
Good luck, Frances. I've got a text here from Stephen in Kurwa, which is actually quite interesting. How do you find a will that was made 20 years ago and the lawyer's no longer around?
Yes, so if the lawyer was a member of the Law Institute, they keep fairly good records of people who were members. Some lawyers, when they close up shop, will deposit their wills with the probate office. There's a scheme that allows anyone to deposit their will with the probate office. So you can search there. That's an online search.
So I could deposit my will with the probate office?
Yes.
And then it would be immediately searchable?
Yes.
Oh, okay.
Yes.
Right.
So anyone can search and see that it's there. Of course, it's a public register. But yes, you can search for that. The other way is to track down the lawyers, and we often have to do this. Googling is a good way. Usually firms don't just close up shop, and if they do, they're very responsible. They report it to the Law Institute and the Legal Services Board. So you can usually track them down with a bit of detective work. If you can't find them, if you make those efforts and you want to leave your number perhaps with someone, I can help you more closely, but it'll take a bit of explaining, and I don't think all of the public will want to spend the time on that.
No, I do actually know some retired lawyers who still keep the boxes.
Yes,
they've got the boxes and boxes in their garage, and that's their responsibility.
Yeah, they do. Or they merge with another firm. So often if you Google, you can find the people online. But the Law Institute or the Legal Services Board is a really good place to look as well.
And good advice that you can you can lodge it with the probate office if you're concerned. Christine in Greendale. Hi, Christine. Christine.
Hello, Christine.
Christine, can you hear us? No, we can't. Sorry, Christine. If you're still there in a minute, we'll take you, but I think you might still be listening. Sue in Keysborough. Good morning.
Oh, good morning.
Good morning, Sue.
Good morning. My question is also about an estranged child being excluded from the will. So just briefly, my brother has been estranged from the family for many, many years. He's living rent-free in one of Mum's properties and now wants to claim title. But the point is my mother wants to exclude him from her will and leave the balance of her estate to her remaining children.
Yes.
Can you describe the circumstances of the exclusion in an addendum to the will? Because my mother is a very private person.
Yes.
And you've just stated that wills are searchable via the probate office.
Yes.
Would the addendum also be searchable, the addendum to the will?
So what if you do it as an addendum, it officially becomes a codicil if it's done in the right way, and it is equally searchable. What I recommend to people is they write as a statement of wishes and give it to the executor and explain why they've done what they've done. Now, if he's occupying a property rent-free, one of the challenges is to get him out now, and the other one is if he's paying rates and taxes and repairing and renovating the property, he'll be claiming a different sort of claim, which is a constructive trust.
He wants to claim it via adverse possession. So anyway, that's a different issue.
Well, that's interesting. You can't claim it by adverse possession in those circumstances. That's not possible. But what he can, there are different types of claims he could bring. I'd strongly recommend that your mother get an accredited specialist to prepare her will and go through the individual circumstances, because I can tell you, I've been doing this for a long time. You've got a battle on your hands. The better prepared you are, if you're forewarned and forearmed, you'll be able to deal with it much better. So the Law Institute, they have accredited specialists. Ask for one in wills and estates if your own lawyer or if your mother's own lawyer is not an accredited specialist or doesn't know the field well enough.
Good luck. So Christine from Greendale is back. Hi, Christine.
Oh, g'day. Good morning. I just want to know, if you write it, we have a will and we forgot to put in executors. Can you add them in?
So you can add them in by a codicil, but who did you prepare the will yourselves?
No, we had someone else do it for us. And then
lawyer?
all the people had changed. He was a lawyer's secretary.
Oh, it's unusual to make a will and not appoint executors. Is it possible the executors have gone?
Yes, they died.
Died, okay.
And that's why we rewrote it.
So what the law says is if the executors have all died, one of the beneficiaries with a substantial interest can lodge what's called letters of administration or a grant of representation with the will annexed. What that means is they've got a share of the estate. They want authority to administer it because everyone else has died. But it might be worthwhile just updating the will anyway, but don't do it with a lawyer's clerk. Go and do it properly is my recommendation too. It's really the amount of money that's spent on claims afterwards. And the problem is the will maker's not around to defend them. They don't. So the courts are trying to work out what did the will maker intend and what went on. Much better just go and see a lawyer and make another will is my recommendation.
Marg in Moonee Ponds. Hi, Marg.
Hello, and thank you for taking my call. Look, my first husband passed away 17 years ago. I remarried 8 years ago to an old friend of ours, actually, and he had long-term divorcee. We've been together actually for about 12 years, but married, as I said, 8 years ago. Our wills, we have a home that we bought together. We put equal funds, paid right down the middle with furniture, everything. And if I should predecease my husband, that home, of course, will go to my husband. And he's written in his will that if when he dies, that home then would be go to my two daughters. And he does have 3 children who are long-term. One went to America, never even said goodbye. Pretty sort of nasty situation.
Very sad situation with the children from the... Yes. So the first thing you need to look at...
My concern is them coming back onto my girls and saying, no, you're not getting that house, but I've actually... put my funds into it.
That's quite possible. The first question for you is whether you own the property as joint proprietors or as tenants in common. There's 2 distinct methods of ownership of that category. If you own property with another person, you can own it as joint proprietors so that there's a trust created over the property. When one dies, it automatically reverts to the other. So that's the most common if you're in a long-term marriage. A lot of second marriages and a lot of newer relationships will have properties as tenants in common, and you have 2 distinct half shares. So your half share can go the way your will says, and his half share can go the way his will says. Now, I'd get some advice from a lawyer, but that's the first thing I'd be looking at. I'd probably change it to tenants in common. There's no stamp duty or capital gains tax consequence of doing that, but that's probably the first thing I'd do, and keep your wills up to date. It's really important.
Marg, good luck with that. And a big thank you to you, Kathy Wilson, for coming in and taking questions today.
It's been a pleasure.
Kathy Wilson there from Kathy Wilson Legal.